So, hi everyone. In today's class, we are going to discuss from section 73 onwards, which deals with chapter 6 and it speaks about the consequences of the breach of contract. So, before that, I would like to have a quick revision about the last session whatever we have discussed on that. So, in the last class under section 71, we have talked about the responsibility of the finder of goods. Okay. So, when we're talking about the responsibility of the finder of goods, under that we have understood that the person who finds the belongings of another person, then and takes the thing or takes the good to his own custody, then that person is subject to the same responsibility as the bailee. So, under the concept of the bailer and bailee, we have already discussed that when there is the two parties, the first party is the bailer and the second party is the bailee. So he is the bailer and who is the bailee? So first of all, the person, for example, I am traveling to somewhere, okay, and I have certain goods which is very useful or which is having a very high price, and when I am absent, okay, I don't feel that those goods should be kept in my home or anything like that. So, in that time, I am assigning those property or those goods to you, that please take care of my things until I come back. Okay. So, here I am the bailer and you are the bailee. The bailer is someone who delivers his own goods or the property to the another person, not permanently. This is not the permanent transfer of the ownership. This is the partial transfer for a short term period or for a period of a certain time. Okay. And the bailer provides his goods to the bailee for a certain duration, for a specific time period, and the bailee takes care of the thing as like a bailee only, not not as the owner of the property. Okay, we can take another example of this. For example, uh, I have visited your home. Okay, so while visiting your home, I have wear a diamond ring. Okay, so what happened? Due to my irresponsibility or anything, I have left my diamond ring at your home. So when I got to know that yes, I lost my diamond ring and where is it? Then I got to know yes, I have left it at your home. Then I'm calling you and I'm telling you that I am having certain kind of the works. So please take care of my ring for 2 days. I'll come after 2 days and take my property from you. So here, for these 2 days of the duration, you are not the owner of the property. You are not the owner of the ring. You are just acting as a bailee of the ring. That means the ring has been taken care of you. You are taking the custody of the ring, but not as the real owner. Okay. This is called the relation of the bailer and bailee, where the bailer is transferring certain thing or the bailer is giving a certain kind of the good to the bailee to take the proper care of it. But this is just to remember thing to do, that this is the partial transfer of the property to take care, to be taken care of. This is not called as the transfer of the ownership from one person to the another. Got it? So when there is the finder of the goods, for example, you are traveling somewhere and during the traveling you lost your purse somewhere. So I have got your purse and I am the founder of the good of your purse. Okay. So when I opened your purse, I got to know that You are having your Aadhaar card, PAN card, all the details in the purse, and I called you that yes, I got your purse somewhere, there is the money up to this amount in your purse, and there is around these cards in your purse. So here I am taking the custody of the purse, okay? And here my responsibility to work as a bailee of the property. That means I'm taking care of the property, I'm taking care of the purse and all the goods of yours as a bailee only for a limited period of time, not as the owner of the property. Got it? So this is called the responsibility of the finder of the goods. And in the next section, we have understood about the liability of a person to whom the money is paid by the mistake or under coercion. So under that we have discussed when there is the uh, yes, under this contract act only, under section 14 to 13, 15, 16, 17, we have discussed that in a contract, when there is the presence of the coercion, undue influence, misrepresentation, mistake, force, okay. So in these circumstances, when there is the fraud, or in these situations when there is a happening of a contract, the contract is considered as the void contract or voidable contract. The contract is not considered as a valid contract when it is done with the coercion, undue influence, mistake, misrepresentation, or fraud. This is what we have already discussed under section 14 to section 18, 19 of the Indian Contract Act. Okay. So, wherever, whatever the situation it is, even if it is about the repayment of the money, if there is the coercion or there is the uh, um, mistake or undue influence by one party to the other party for the repayment of the money, in this case the money which is paid or delivered by mistake or coercion must need to be repaid or returned to the person who has paid it. Okay, just take a small example of this. Okay, yeah. So what I was talking about, yeah. So just take a small example of this. For example, I have paid you the amount of 100 rupees. Okay, uh, yeah. So for example, there is a person A and B. They have paid the amount of 100 rupees to C. So what happens next? When A and B together paid a sum of 100 rupees to C, then at this point of time, C is liable to give the payment to A and B to repay the money. Okay. So what C did, C has paid the money to A. Okay. What happens that uh, B is coming to C, and B is coercing or threatening to C that if you are not paying me the amount of 100 rupees, I am going to sue you, I am going to do any kind of the harm to you. So with the due fear, what C did, C again paid the amount of 100 rupees to B also. So here C has taken the amount of 100 rupees from A and B together. But he was supposed to pay the amount of 100 rupees to either A and B, either A or B, or A and B together. Okay. What he has already did, he has already paid the sum to A before ahead. But even after the payment, B is coming and threatening to C to pay the money again to him. So with the coercion, what C is doing, C is doing the repayment of the sum. Okay. So after the repayment of the money, what happens that C is suing in the court of law against B that I have paid this amount of the extra 100 rupees to B itself, and here C is liable to get back the amount of 100 rupees which he had paid extra to C. Okay. Let's take another example of this. Okay. For example, you are traveling at a through the airports. You are traveling through a flight. Okay, and the flight has taken by mistake, that is not intentional, but due to certain extra charges of 5,000 or 6,000 has been added up in your bill, and you have to pay those 5,000 or 6,000 to the airline. Okay, and you have paid that extra amount of 5,000 to the airline itself. After the payment, you are complaining to the Air Force that this is the extra amount or this bill has been done by mistake. So I need to get back my amount of 5,000 which I had paid extra. So here the airline is responsible or is liable to pay back the specific amount of 5,000 rupees which has been paid by mistake by the passenger or paid through the false bill to the passenger. So this is what we have discussed under the section 72, that when there is due to coercion or mistake, the extra payment has been done or the money is paid with an excess amount, the additional amount must need to be repaid or paid back to the person or paid back to the person who has given it. Okay, this is what we have discussed under section 72. Now coming section 73 onwards, it speaks about chapter 6 and it deals with the consequences of the breach of contract. So what do we understand by the breach of the contract? When we are entering into a contract, okay, mindfully we know that whenever we are dealing a contract with someone or with any other person, then we have all the right, all have responsibility, all have the duty to maintain the contract, to complete the nature of the contract, whatever we have signed, whatever the terms and conditions of the contract, that we must need to follow up. Okay, so when there is the contract between two parties and the parties are unable to fulfill their promises to each other, okay, and under the contract that we have already understood, when there is the promise, when the promise is accepted, first there is the presence of a proposal. When the proposal is accepted, it becomes a promise. The promise, when it is added up with the consequence, with the compensation or the amount of any kind of the remedy, it becomes a agreement. It becomes an agreement, and an agreement enforceable by the law becomes a contract. Okay, so promise added with the consideration becomes an agreement. Agreement added with the legal availability becomes a contract, that we have already understood. Okay, so when there is a contract, that means the agreement has the legal enforceability, the agreement is totally valid. Okay, and the agreement is not voidable in nature, is it is totally valid according to the court of law, and the contract has been done by the two parties. That means, for example, there is a contract which is totally done with all the fulfilled terms and conditions. But after the fulfillment of the contract, the terms and conditions of the contract, which is by the promiser or either by the promisee, by any of the party, is unable to fulfill the terms and conditions of the contract. In that specific case, that is called the breach of the contract. That means the violation of the contract. Whatever the terms and conditions of the contract was sequenced or has been planned, that is unable to be followed up, that is unable to be taken care of, and that is called the breach of the contract. Okay. So under section 73, let's have a look what this section 73 exactly deals about. So under section 73, so first point, it speaks when a contract has been broken, the party who suffers by breach of the by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of the thing from such breach, which the parties knew when they made the contract to be likely to result from the breach of it. So what does it mean? When there is a party who is suffering from the breach of the contract, that party is entitled to compensation for the losses which is directed or which is caused due to the breach of the contract and would naturally occur or losses that were foreseeable by both of the parties at the time of the making of the contract. That means the genuine amount of the losses which could be predicted, which could be foreseeable by the parties, that amount must be compensated to the party who is suffering the losses due to the breach of the contract. Okay. Let us take an example of this. For example, you are entering with me to the buying of 100 tons of the rice. Okay. Like I am, मान लो I am a farmer and I am having a big land and I am doing the crop business and I'm producing rice. Okay. And there is a deal between you and me that you are going to take 100 tons of the rice from me. Okay. So according to the deal, you were supposed to take that specific amount of the grains from me. But before the happening of the contract or before the proper delivery of the contract, you denied me that you are not ready to take those grains from me. Okay. So I was ready to deliver you the goods, but you are not agreeing to take the goods and you are not agreeing to pay me the amount of 15,000 of the rupees which you were supposed to give me before the agreement. Okay. So there is the agreement. I'll provide you the grains and in return you will provide me the money of the 15,000 of the rupees. But at the last moment, you are denying that no, I am not ready to perform the contract and I don't want the grains from you. So it is clearly seen that if I am not selling the grains to you, then I am going to suffer loss. Okay. And which kind of the losses I am going to suffer? My grains will be wasted and migrants is unable to be sold at any other places because I have done a deal with you and I have already denied my other customers to sell the product. So here it was clearly visible that the specific amount of the 100 tons of the grains which I could not sell you, if I am unable to sell you that, if you are unable to perform your part of the contract or to receive my product, then I'm going to suffer the amount of the losses which could extend the amount of 10,000 or 13,000 as per the nature. The land cost, the the cost of the production, and I have already booked the vehicles or the trucks for the delivery of the product, and the person who has with whom I have done the agreement for the delivery, that person is also not going to pay me back the money I have paid him or her. So all the losses hereby occurring that might extend to 15,000 or the 13,000 of the rupees. So the specific amount of the losses which can be foreseeable by the parties, which can be guessed or observable by the parties. That means if I am a party over here, I know that if I am not performing the contract, you are the party over here, you know that if you are not performing your contract, this kind of the losses I am going to face. You are already aware about the fact of this, and I am already aware about the fact of this, or even if I am not aware, it is clearly visible, it is clearly observable, it is clearly predictable that what amount of the losses the party is going to suffer for the non-performance of the contract. So those specific amount those specific amount of the compensation must be need to be paid. Okay. The next point, no compensation for the remote losses. So what does it mean? It means when there is the presence of a contract, okay, and when there is the loss by one party to the another, then if the loss is itself remote in nature. So what do you mean by the loss as per the remote in nature? That means when the loss is indirect and not direct in nature, then the compensation is not to be awarded to the party. So, what do you mean by the indirect loss? The loss which is not direct in nature. Just take an example of this. For example, we are traveling somewhere, and in the midway, you are telling me that you are unable to perform the contract and you are unable to come and pick me. Okay. For example, we have booked a Uber or we have booked a driver for our journey, but the driver is denying at the last moment that no, I am unable to come. So, getting no choice, what I did, I found another driver. I found any other person who is able to drive and asked him to take me to that particular place. Okay. So when I am traveling with that another person, when I have give the responsibility of the driving to the other specific person instead of you, and I was totally predicted that yes, you will come, you will take me, you will be my driver, you will drive to me to the specific place. But when you are denying, I didn't get any another choice, and I have to take any other driver. Okay. So while traveling, or when I reached the place, or when I was coming back, there is an accident happened to me by that other driver. So here tell me, am I liable to get the compensation from you for my damages? The answer is yes and no, both. How does it work? Let me explain it. The first point is here I was supposed to travel with you and I have appointed you for the driving purpose. Okay. You didn't come. So when, as you are my regular driver, you are taking the amount of 1000 rupees per day. But the another driver who is the outsider, he came and he took the amount of 3000 rupees of free from me. So here I suffered the loss of the 2000 rupees from you, from the another person. So here, as this happened just because of your non-performance and your irresponsibility, here you are liable to pay me the compensation of 2000 of the rupees. That means you are liable to pay me the amount of the 2000 rupees, because यहाँ पे I was supposed to pay you 1000 rupees to you, but the extra 2000 rupees I had to pay to the other person because you are unavailable. So while traveling with the person, what happens? That person made me an accident. Okay. And I am suffering the medical expenses of 50,000 of the rupees. So are you liable to give me the compensation for that? No. This is not considered as a direct loss of mine, because here the person who was driving, who was taking me to the specific place, he is also a certified driver. We all know that maybe you were unavailable, that is why I had to take another driver and I suffered the loss of physical injury. But I am not responsible for this. And here you are not responsible for these indirect losses. This is called the indirect losses. Okay, this is called the remote losses. So when you are suffering a loss due to me, but this is due to the indirect activity, then here you are not liable to pay compensation to me. Yes, here I am liable to get the compensation from you of the amount of 2000 of the rupees which I paid extra to the another driver. But here I am not liable to get the compensation from you up to the amount of the medical expenses, because that is what the activity which is not considered as the direct losses. This is called the indirect loss or remote loss, and I am not able to get the compensation for those kind of the losses itself. Okay. Now, the another clause is talking about the another provision. What does it mean? Obligations resembling the contract. So, what does you mean by the obligations resembling the contract? That means when there is the obligations is arising due to the contracts that has been established, if one party fails to fulfill the obligation, the affected party can seek compensation as if there were a contract in place. Okay, so how does it work? The first thing, when there is the case of the obligation instead of the contract, but it is exactly acting like a contract, it is exactly working like a contract. For example, you may heard about the quasi contract. What do you mean by the quasi contract? Quasi contract means there is not a proper presence of the written contract. There is no agreement between the parties over there. There is no legal liability of the parties between each other. There is no legal compatibility or legal agreement between the parties for a contract over here. But yes, there is the obligation of the one party towards another due to the performance of the certain activity. For example, I have not ordered for a specific kind of the service. I didn't applied for a specific kind of the service, but I am getting that service from the another person. But and even without letting the person know that I am illegally, without any agreement, I am accepting that service, I kept enjoying that specific service. And yes, in these circumstances, when I am capable of enjoying that specific service without even the presence of the proper contract, then I have the obligation to do the to provide the consideration amount or to provide the compensation to the specific party for the damages or losses of the contract. Okay. For example, there is a pizza delivery boy. Okay. So what he did, he went to deliver a pizza up to a certain location. Okay. So what happens that instead of delivering at a specific place, he delivered the goods at a wrong place. By mistake, he was not aware about the fact that wherever he's delivering the contract, that place is actually a matlab, wrong place to delivery. He didn't know about that. So what he did the delivery of the product and he came back. The person who was staying there, he accepted the service and even he enjoyed the pizza. He ate the pizza. So here, when the delivery boy got to know that yes, the pizza has been misplaced, or the pizza has been delivered at a wrong place. Then the pizza had already been eaten by that specific person. The pizza has been already been eaten by that another person itself. Okay. So when there is the situation that the delivery boy has wrongly placed the pizza to any other's home, and the other person who is not the buyer, what he did, he accepted the service and he has also enjoyed the service. He ate the pizza, he enjoyed the pizza. So here, instead of the person who has ordered the delivery, the person who has enjoyed the property is liable to do the specific amount of the payment. Got it? So when, as we have understood, when there is the presence of a quasi contract, then in that circumstances, when there is a party, if any party is providing his obligation, even if there is the absence of the contract, but one party is performing his all obligation, the another party is also liable to provide his obligation or the consideration to the other party. And if the party is unable to provide the obligation to the other party, then the affected party can seek compensation as if there were a contract has been in place. For example, as we are talking about the pizza delivery, I told you that the pizza was costing the amount of 1000 मान लो, okay. But after eating the pizza, when the pizza delivery boy went to the home of the stranger, and he told that, sir, by mistake the pizza had been delivered to your home, so can you give me back the pizza? The person is saying, no, sorry, I cannot give it back to you. Then the person is asking, why, sir, why you cannot give me the pizza back? And the person is saying that how I am able to give you back the pizza because I have already eaten it. Then the delivery boy is asking to the person to provide him the amount of 1000 that, sir, the pizza you have just ate, it cost about 1000 of the rupees. So please provide me this 1000 of the rupees because the person who has ordered the pizza, he has already lost the pizza and the pizza has already been delivered to you. And you have enjoyed our service, so you have to pay us the amount of 1000 of the rupees. But the person is straightforward denying, no, I won't pay the amount of 1000 and I'm not going to pay. So here, the pizza delivery company can sue the person to whom the pizza had been delivered mistakenly to pay the amount of 1000 of the rupees. Here, the person who has enjoyed the free service is bound to pay the amount of 1000 for as the service charge as the amount of the pizza, because this is the unexpected service. Even if there is no presence of the contract, but there is the untold contract between the parties that happened. There is the presence of the quasi contract, and here the party who has delivered the pizza is liable to sue the another party who has enjoyed the service to pay the money as if there is the presence of a real contract. The party can act as like there is the presence of the contract even if there is no contract is being presented. Okay. And the last part, it speaks about the mitigating losses. So what does it mean? It means when the compensation is being calculated, okay, the compensation amount is being calculated, at that time of the calculation of the compensation, the one thing will taken care of. What is that? That if the party, okay, if the injured party could have taken the reasonable steps to lessen the impact of the breach, this should be the amount of the losses should be less. So this factor will also be taken into consideration when there is the calculation of the compensation to mitigate or to reduce or to remedize the losses occurred. For example, if I have lost, for example, there is a specific kind of the delivery to me, and I have been suffering loss due to the non-delivery of the specific product. So here I have been suffering a kind of loss due to the non-delivery of the product. Here, if I would have taken proper care, then the loss or the damage amount would be lesser than that. This factor will also be taken into consideration while while counting down or while calculating the compensation amount. Okay. So this is all explained under section 73 of the Indian Contract Act. Next comes your section 74, which is a bit lengthy section. And the last section of chapter 6, it is section 75. Okay. So section 75 speaks about party rightfully residing the contract entitled to compensation. When the party is rightfully residing the contract or denying the contract, then he is entitled to get the compensation from the other party who has rescinded the contract. We have already discussed on this in details in the last class, and we have also had a detailed discussion on this. For example, let's understand this through an illustration that I am a singer, okay, and you are appointing me to do the performance of the singing for next 2 months, 5 days in a week, okay. So as I promised you that yes, I'll come for the 5 days in a week, and I'll do it for next 2 months on a regular basis. So what is happening? At the 6th day, I breached my duty. I mean, I came for first week and second week. Uh, the day one, the first week, 5 days I completed my work, and the second week, the first day, the 6th day, I breached my duty, and I am not coming to perform my performance. Okay, and I take 1000 rupees per night for the performance. So here, just because of my absence, the owner, the manager of the theater, is suffering a huge amount of the loss because there was the audience to see me, to hear me, and as I was absent, all their tickets was on waste. So the owner has to suffer the emotional damage, the public taunt, and the refund of the money. All these problems the owner has to face, the theater owner has to face. So, what the theater owner is doing on 7th day, when I'm coming to do the performance, the theater owner is cancelling or resigning the contract. The owner is saying, no, I don't want to continue the contract with you anymore. We are quashing or terminating the contract due to your non-performance. Okay. So when the contract is closed, the contract is terminated by the owner of the theater, then in that specific circumstances, as I was absent for last one night, I have to pay the amount of the compensation due to my non-performance, which the owner has been suffered. But here, the owner has all right to get the compensation from me just because my non-performance. And secondly, the owner has the right to resign the contract or to deny the contract or to close the contract due to my non-availability or non-timely performance of the contract. Okay, this is what the section 75 space speaks. And one more thing, remember over here, if on 7th day the owner of the theater is accepting the performance of mine, if on the 7th day, 8th day, and the 8th day I am going and doing my performance, even after I was absent on the 6th day, the owner accepted my performance on 7th day, then the owner is incapable to terminate the contract with me, but the owner is capable to get the compensation from me. That means on the 6th day, I did my performance of the contract, but on the 7th day, I went and did my performance. The owner accepted my performance without saying anything. Here, the owner is liable to get the compensation due to the breach of the contract on the sixth day from me. But the owner cannot terminate the contract because he has accepted me on duty again. But if on the sixth day after the non performance, the owner wants to terminate the contract or resign the contract, he has full capability to do so. This is explained under Section 75 of the Indian Contract Act. Next, all the rest provisions we are going to discuss in the next class in details. This is all for today, guys. We can wrap the class over here. See you all in the next class. Thank you.